So I'm just going to use my last 5 minutes here to go back to first principles, if I can, and talk about what a chargeback actually is, because I think chargeback is certainly one of the terms I hear most in the Strata world, but interestingly enough, you don't find the term in the Strata Property Act, and as I understand it, as it's used by people in the industry, it's simply a term that's used for an expense that is incurred by the Strata Corporation, and then the Strata Corporation is looking at a certain point to allocate it to a particular unit. And so what that causes is a situation where you have to account for chargebacks in the bylaws. So if a Strata Corporation incurs an expense and they then want to charge it to an owner's Strata lot account, there needs to be a basis for that. And that basis will be found in the bylaws. What the bylaw should do is create a debt obligation as between the Strata Corporation and the owner. And the two ways to do that there are by creating an obligation that the owner pay an amount to the Strata Corporation, or granting the Strata Corporation authority to collect an amount from a Strata lot owner. And so I had two cases. One was both very similar. Lawrence was the first case. But I'm going to talk about the Szabo case just because it has a quote in it that I think is very instructive. And so in this case, the Strata Corporation conducted repairs with respect to a number of leaks, and in accordance with its investigation, it determined that the leaks originated in a particular unit, and so at the end of the day, they purported to charge those costs back to the owner. The owner then disputed that chargeback before the CRT. And so very, very vague language, first of all, was used by the Strata Corporation in notifying the owner of the chargeback. So they had simply sent correspondence saying that the repair costs had been deemed to be the owner's responsibility as the owner of the Strata unit. No more specifics than that. And they also said the amounts had been charged in relation to leaks from the owner's unit, without any further explanation in terms of the legal mechanism by which the charges were indeed charged back to the owner's account. And so the CRT said this in its reasoning, and I think the paragraph is an important one because it gets back to my point, is that the legal justification of a chargeback is always found in the bylaws and rules. And so the CRT said this: Section 116.1 of the Strata Property Act allows a Strata Corporation to impose a lien on a strata lot for specific types of debts. A chargeback of repair costs is not a lienable charge under the SPA. In order to collect amounts that cannot form the basis of a lien against the strata lot, a Strata Corporation must have the authority to do so under its bylaws. Specifically, a Strata Corporation's bylaws must create an obligation that the owner pay or grant the Strata Corporation the authority to collect that amount. Further, a demand letter cannot create an obligation to make a payment. And so in accordance with that paragraph and that reasoning, the CRT ultimately concluded as follows. The Strata Corporation in this case did have bylaws permitting the Strata Corporation to charge back the amount of an insurance deductible and also to sue a strata lot owner to recover repair costs, but they did not have a bylaw that allowed them to skip those steps or operate outside of those steps to simply allocate repair costs to a strata lot owner. And therefore, in accordance with that, the chargebacks were invalid. So I think the takeaway here, and oftentimes I think the reasoning by strata corporations and perhaps strata managers, is that chargebacks should be based on what's reasonable. And certainly you might think that it's reasonable to charge back an amount to a strata lot owner if it's deemed after a proper investigation that a leak indeed stemmed from a particular unit. But what this case and those lines of cases tell us is that a chargeback is not based on what's reasonable. A chargeback is based on what is set out specifically in the bylaws. And that leads to the obvious conclusion is that the bylaws should certainly be reviewed from the Strata Corporation from time to time. If there are certain amounts that they believe that should be charged back to strata lot owners, then they have to account for that in their bylaws, and if it's not accounted for, then revise the bylaws.
Did the owner sue to recover? Or did the strata sue to recover since they could?
So it didn't get that far, but I suspect not. It was a relatively low amount, and the CRT action was brought by the owner. And so in order to sue and perhaps get a judgment in negligence or nuisance, as Sean was saying, you either do that on your own or you pay a lawyer significantly more than what the issue was worth in this case. Yes?
What is the maximum you can go through on a CRT? Is there a maximum, 25,000, 5,000?
No, the CRT has jurisdiction to issue awards without limit.